Good evening class. Online class, is the AV working? Online class, is the AV working? Okay. So, today we will be discussing polity and governance ka current affairs. Topics are WHO Global Tuberculosis Report, surrogacy law in India, social audit and SIR, provisions for tribunals has been struck down by Supreme Court, and revisiting gender neutrality. Okay. First topic is WHO Global Tuberculosis Report 2025. Possibility of this question in prelims is very higher. See, first and foremost, let me explain something about TB. Okay. In India and in the world, a single infection, that is a single disease causing, sometimes let us say death happens due to multiple things, organ failure, okay, or 2 or 3 diseases mixed up together. But in the entire world, if you take the highest cause of a single disease causing death is your tuberculosis. Understanding? So, this tuberculosis has claimed so much life in the global as well as in Indian medium. Now, your India has taken a pledge. That is TB Mukt Bharat by 2025, which means this was government's challenge that we will eliminate TB by 2025. In another month 2025 is going to end. Government is nowhere nearby to eliminate TB in 2025. The question now will come as to what does it mean by eliminate? Eliminate is different, eradicate is different. Eliminate means less than 1 case for 1 million population, which means 1 person only should be getting TB in out of 10 lakh population. So, your government was aiming to reach TB Mukt Bharat by 2025, but we could not achieve this. Then why is this? See, again I told you why this is important for your this upcoming prelims is, this is just getting over in 2025. Understanding? I told you anything that starts in 2025 or ends in 2025 or something that started in 2019 also becomes important for prelims. This is extremely important. TB Mukt Bharat 2025 could not be visualized. Write down what does eliminate mean. Okay. So, we could not eliminate TB, but again why this news is interesting means, for the first time the percentage of TB affected people fell, and also the global coverage, once you are affected with TB, the medicines, the coverage, the diagnostics, all of those increased. What is it? In 2024, that is the last year, number of TB cases declined to how much? India's TB rate fell by 21% compared to 2015 level and 2024 level. This is the fastest it has declined in over 10 years compared to your global level. Global level it has been less than this, but India got 21% of reduction in TB cases. Okay. We'll move ahead. So, if you see, every year 10.7 million new TB cases are added. In that 10.7 million, just assume if 10 million people get TB, 1 million die because of TB. Okay. In this 131 okay, per 1 lakh people have ended up getting TB, and in that 11.5% has died. TB is among the top 10 causes of death because of a single infection. Okay. Now, if you see countries which are having higher TB burden, first place is by India. Almost 30 countries account for 87% of TB cases. First position is India, it contributes 25%. Second is Indonesia with 10%, Philippines with 6.8% and China with 6.5% and Pakistan with 6.3%. TB is much more prevalent in India compared to any of the South Asian neighbors. Done? Now, what is this TB? It is a contagious airborne disease, which means it can be spread from person to person. How is it spread? Through airborne. Understanding, if anyone coughs and water droplets comes in and sprays, even just few of those bacteria are harmful enough for a person to get infection. It is caused because of a Mycobacterium tuberculosis. It largely affects lungs, but it can also affect other body parts. Okay. There are two types of TB, pulmonary TB which affects the lungs most. Next is extrapulmonary TB that affects apart from your lungs, such as your brains, bones, your lymph, kidneys, all of those. Two types of tuberculosis, pulmonary TB, extrapulmonary TB. Okay. It is a contagious disease. Now, if you see India pe what are the achievements? 2015 pe there were 237 TB cases for 1 lakh people. In 2024 it almost halved its 187 per 1 lakh population. In 2015 28 people died for 1 lakh members. In 2024 21 members died per lakh members affected with TB. Also, one important thing of this is your treatment coverage. 2015 anyone who got TB, only 53% was covered. In 2024 91% of people were given TB coverage. Still, why is India accounting for 25% of your global TB? Means answer is simple. Because of people living in excessive slums, congested areas, alongside this issue about your diabetes, HIV, AIDS, these were also contracting factors which started affecting these people more. And also recently, especially in 2024, they have identified more than 3 million people are getting affected because of your air pollution alone. Okay. And worst thing that has started happening more is even children are getting contracted with TB. Children are getting contracted with TB. How? Because it is a spreadable disease, communicable disease. So, India accounts for world's 28% of TB. What leads to tuberculosis? Undernutrition, poverty, HIV, diabetes, smoking, alcohol use. How is India able to reduce its TB numbers? A, it has got up a huge rifampicin testing, that is to test whether a person has got TB or not. They have also started using AI enabled chest x-rays. I told you lung is what it affects primarily, right? And it has also brought in lot of, see this is the most important thing, BPALM regimen, okay, and also your DRTB treatment, that is drug resistance TB treatment. What this is, I will explain, but as of now just write down these two. Okay, this is what is able to bring a lot of people under coverage. Look at this. Done, we will move ahead. Your BPALM regimen means See, for tuberculosis, usually painful injections are given for a lot of time as vaccines. Under your BPA-LM, this is nothing but vaccine, but it will be given in the oral form. With this, earlier the treatment used to take from 18 to 24 months, now it is reduced to a short period of just 6 months in time. Okay, so this is one of the ways that they are trying to control the number of cases. And one more thing is TB is a curable disease. So, in what they found out, they decided that there are 19 crore people who are getting screened, and in that 24 lakhs are having TB and 8 lakhs are having asymptomatic, that is there is also something called as missing TB cases. Many people are having TB, but because of misdiagnosis or not reporting to government data, leading to this many TB cases are not known. Another thing, how government is trying to support this TB affected patients is through your Nikshay Poshan Yojana. This is a nutrition support program, wherein for anyone who is affected by TB and belongs to a particular section, 500 to 1000 rupees will be given for them, and also additionally per month 3000 to 6000 rupees will be spent on them with regard to treatment costs. Nikshay Poshan Yojana. Per month 500 to 1000 rupees. So, what is Indian government trying to bring up schemes in order to reduce TB? First is NTEP, which is otherwise nothing but Revised Nutrition Tuberculosis Control Program, wherein they want to eliminate TB in 2025. Again I told you, eliminate means less than 1 TB case for 1 lakh population per year. That is your more of your TB strategy that they wanted to do, but they couldn't visualize it. How are they trying to control the TB? It is through detect, treat, prevent, build. Okay? Eliminate means less than 1 case for 10 lakh population. What are they trying to do in order to bring your TB cases under control? Your cartridge based nucleic acid amplification test or CBNAA, wherein this is nothing but the tests which will identify in a molecular level as to whether a person is affected by TB or not. Okay? It detects the samples directly from your DNA. That is why molecular test. Done? Other things like we spoke about your BPAL regimen, which is bedaquiline, pretomanid and linezolid. Okay, these are all the chemicals that are used together to control your tuberculosis. This is a oral treatment for drug resistant tuberculosis. Okay, this can be cured in 6 months. Earlier it used to take 24 months. Done? See, here you would say patient friendly regimes. Patient friendly means you should not keep on doing this painful injections. Okay, see, for older people you will keep putting injections, fine, but for children, for their case some oral vaccine had to be found out, that is this. So, I will read out a question from this, you tell me the correct answer. Consider the following statements regarding India's TB elimination efforts. India aims to eliminate TB by the year 2025 ahead of WHO global target. Correct, it aims to, it wasn't able to do, but it aims to. TB elimination is defined as less than 1 case per million population per year. Correct. BPALM regime has reduced the treatment duration of drug resistant TB to about 6 months. Correct. So, all three are correct. Next is surrogacy law in India. See, there are two things you have to know with regarding to surrogacy. We have two types of surrogacy, commercial surrogacy, altruistic surrogacy. What this is, little bit later I will explain. Commercial surrogacy is banned in India. Altruistic surrogacy is allowed in India. Now, whatever we keep speaking about surrogacy laws, it will be only about altruistic surrogacy, never about commercial surrogacy, because it is completely banned in India. Understanding? Now, the question is, what is surrogacy? Okay. Surrogacy pe also there are two types of surrogacy, traditional surrogacy and gestational surrogacy. Okay. Listen to this. In traditional surrogacy, let's say what I am explaining now is traditional surrogacy. There is a man, woman and a surrogate mother. Surrogacy means when the woman can't have a child on her own, they will end up using someone else to produce their child. When we say traditional surrogacy, this person, this woman ka egg will be used with this male, artificial insemination, or some other donor ka egg sperm will be mixed and then she will carry the child. In here this surrogate mother ka egg only is used. Understanding? So, she has a link to the child, even though she can't claim the child, but this is how traditional surrogacy. Next is gestational surrogacy. Okay. In gestational surrogacy, male ka sperm, female ka egg is mixed and then an embryo is made, and this embryo is implanted into her uterus. Okay, so this lady carries a child which has no link to her, but she is just as a conducive medium. She will just grow their child for them and gives. This is gestational surrogacy. Understanding? Clear up until here? See, now I told you commercial surrogacy is completely banned. Whatever act parliament passes, it will be only about altruistic surrogacy. Now, the question is not about anything about should surrogacy be there or not. The issue comes is, let's assume there is a male and a female. They don't have any children, they are married for 5 years, it is proven from your medical council that they are infertile, means they can go for surrogacy. Now, they got one child, okay, either through adoption or through surrogacy, whichever way it is, they have one living child. Let's assume this family decides, I want one more child. Okay, this is where the issue is coming. Government of India has passed a law that tells if you have one healthy child means either that first child is not mentally ill or it is not having any grave illness. Okay, and if either the child is adopted or surrogate or whatever it is, or you yourself biologically produced, doesn't matter. When you already have one healthy child means you cannot get one more child through surrogacy. Understanding? The question comes as to, now the petitioners, these people are facing, why? Do you know that there is in India a case called as second time infertility? Maybe first time they produced a child, but second time they are not able to produce a child, and the want for baby is higher in them. Okay, one condition. Second thing is, we don't have any rule in our country that if there is only one child for one family. then how are you telling in surrogacy only one child only I can get it? Okay. Third thing is reproductive health is a part of Article 21, which is right to life. How are you able to tell me that I should not have one more child? Understanding? Now, for this government is telling, see, if it was only about you both, we wouldn't have bothered. But it is about one more individual here, that is the surrogate. Understanding? Her body, let's assume we keep allowing altruistic surrogacy pay, one of the rules is they cannot pay any money for this person to have a child, only medical bills can be paid. And if that particular person is already being misused because of economic condition, then it will become a position where women coming from lower economic standards will be used like a medium or a body to just produce children. Your Article 21 is your right to life, that does not mean you will take away their right to life. Yes or no? See, they may tell we are not forcing them, yes, but they have bad economic condition, they have no other way, that means they have to succumb to this. So, we will not allow that. And also they are telling this surrogacy, whatever you are calling, this is not coming under right to life. Surrogacy is not a right to life, it is not a fundamental right. It is just a statutory right. That is, you can go for surrogacy in so and so condition we have mentioned. Now, both of them are standing their ground. Both of them went and approached the Supreme Court. Okay. Where they are telling we need, even though we have one healthy child, we need one more child through surrogacy, make that happen. Government is telling no, these people will be completely exploited. Supreme Court told, see, condition is valid on their side also. We cannot tell government is being totally unreasonable in the restriction. India's growing population is becoming a huge concern. At the same point of time, there is a possibility of misuse of this section of women also. But despite that, we also listen to your argument. We will in length detail and debate about this surrogacy and we will speak about it. That is what your judiciary has told, that is what this case is about. Okay. So, your surrogacy law is being challenged under reproductive autonomy. You have no right to tell how many children we can have under Article 21. Now, in this, the act that we are discussing is Surrogacy Regulation Act of 2021, specifically section 4(3) of C2, the clause, where it bans surrogacy if a couple already have a biological child, their own child, or an adopted child or a surrogate child. In either of these three cases, you cannot have another child. Okay? But there is one exception. The exception is if that child which you are already having is having any disability or life-threatening disease or incurable illness, then you can go for surrogacy. Done? So, one thing I want you to notice here is countries like Russia, Georgia, Ukraine, Colombia, Iran and few states of USA allow for commercial surrogacy. France, Finland, Italy, Japan, Spain, Sweden, Switzerland, Hungary, Ireland have banned all forms of surrogacy. No form of surrogacy is allowed in their country. This is also one extreme, that is also one extreme. So, in between path is India, which tells we will not allow commercial surrogacy, but we will allow altruistic surrogacy. Understanding? We'll move ahead. So, the people who are telling is secondary infertility. Even though we have had a first child, there is a possibility, and this occurs more than 10% of the world population, where secondary infertility is there, and there is no legal one child policy in India. The issue comes is there is inconsistency in the law itself. If the surrogacy law of 2021 bans that you cannot go for surrogacy, There are two other acts that tell differently, that is Hindu Marriage Act and Juvenile Justice Act. These two are telling that you can have multiple children, meaning Hindu Adoption and Maintenance Act, this applies for all the section of Hindus, your Buddhists, Jains and Sikhs. According to them, you can adopt a child, okay, even when you have a biological child, and you can have more than one children, and for all these children you can divide your inheritance. How come this law is telling you can have more child and surrogacy pay you are telling you cannot have more child? There is inconsistency in this. That is what people are pointing out. Another thing is Juvenile Justice Act of 2015. This applies to all religion. Okay, this deals about orphaned children, abandoned children and surrendered children. All of them can be adopted. So this also indicates that you can have more than one child. This is also being inconsistent with the surrogacy law. So government is telling surrogacy is not a fundamental right, it is only a statutory right. We are bringing these changes in order to prevent misuse and exploitation of another woman, and the restrictions are reasonable and it is to protect surrogate mothers. Okay, this is the government stand. What judiciary is telling is the restrictions are appearing reasonable. There is also huge number of population growth. We will further in detail look into the matter and let you know. So surrogacy framework with regarding to the 2021 is only altruistic surrogacy allowed, commercial surrogacy completely banned. Commercial surrogacy means you carry someone's child for the money they will pay. Altruistic surrogacy means the woman who will be carrying the child has to be a relative of the people. Now in this case there is also eligibility given. A male should be, okay, legally married to a woman. The male should be of 26 to 55 years of age and the woman should be 25 to 50 years of age. This surrogate woman should be about 25 to 35 years of age and already she should have a child of her own. Understanding? Apart from a husband and wife, that is a couple, a divorcee or a widow can also opt child through surrogacy. They should be in the window range of 35 to 45 years. Okay, and if any of these people have their own children, adopted children or surrogate children, they can't have one more child. Okay, the surrogate mother should be a close relative of the intended couple. She should be married, she should have at least one child and she can be a surrogate only once in her lifetime. She cannot have more than two. And her age should be between 25 to 35 years. So this applies to your donor egg stories. I told you in traditional surrogacy, no, where how the donor egg will be given and all this, here it is not allowed. And also when a woman is having MRKH syndrome, otherwise called as Mayer-Rokitansky-Coster-Hauser syndrome, which means in this condition it is a congenital reproductive disorder. A woman born with this disorder can produce eggs but she cannot carry the child. In that case a surrogate can be allowed. Okay, this is the same thing. Okay, let us come to the question. Consider the following statements regarding surrogacy law in India. Only altruistic surrogacy is permitted in India under Surrogacy Act of 2021. Yes, commercial surrogacy is completely banned in India. Commercial surrogacy is legal but regulated in India. It is illegal, it is completely banned, it is not regulated. Couples with an existing biological child are generally not permitted to opt for surrogacy. See, the keyword here is generally. Generally indicates what? Remember I told you if they already have a child and if the child is having grave disorders, illness, that time you are allowed. So this generally indicates that. So this is correct. 1 and 3 are correct. Next is social audit for SIR. first and foremost, Election Commission of India recently had your SIR for your Bihar elections. In that, it has also told we will conduct SIR version 2.0 for 12 states or union territories. The next upcoming elections will be for your Tamil Nadu state assembly elections, where they have held that SIR is a huge issue where it is leading to mass disenfranchisement, which means a lot of masses, lot of voters are losing their right to vote. Understanding? We will see what SIR is. Okay. SIR stands for Special Intensive Revision. This is conducted by Election Commission of India, and it has the ability to conduct this through your RPA Act, Representation of People's Act. What is SIR? See, it is re-verification. Election Commission of India decided that if I have to conduct election here, there will be lot of bogus votes or there will be outdated voters. Now, I will conduct an SIR, Special Intensive Revision. That is, I am going to revise the voter list, where you all have to bring your documents, show that you are living here, then your name will be on the list. The issue is, after this was done, recently Bihar pe, lot of people lost their names from the voter list. Majority of them were women, Muslims, backward section. Most affected was your migrant section. Why is Election Commission doing this? They tell we have to clean the electoral rolls which are filled with all bogus votes. And second thing is, we have to remove the duplicate entries, and this will also be helpful in finding out how the migrants are in India, how much migration is happening. Okay. How are they able to do this? Through your RBA Act of 1950. Through this act, Election Commission can do this. In this, one of the issue is, key important thing is, section 19 states that you have to be ordinarily resident here, you have to be living in this particular area if you have to vote here. Now, what about some migrants who would have gone off for long amount of months? Yes, those people are getting affected. Now, one thing is, seasonal workers or your migrant workers, let's say Bihar pe when they were conducting, their owner did not allow them to go to showcase the data. Then it's like they have lost their vote, they can't vote anywhere else. So, Bihar ka experience has pointed out drop in adult electoral ratio. After they conducted this SIR, large number of data of people were missing, adult ka. Majority of women and Muslim voters data was deleted. Administrative failure is coming from the fact that there were many, the whole point of SIR was to remove the duplicate entries, but there were a lot of duplicate names, bogus entries and inconsistent deletions seen. Alongside that, anyone who didn't have the right documents obviously meant that they lost their voting rights. It became controversial for one thing is, it looked like citizenship screening, that is, you are a citizen of this place, then you have to show you have the document or not, otherwise you are not a citizen. So, almost they started questioning the rights of the people, and it became, the difficulty was, if your name is missing, the government was not to do anything. You have to go find out in voter list whether your name was not there. If it's not there, you voluntarily have to go to government and tell my name is missing, see all these documents. So, the burden of proof was shifted to the citizens rather than the state. Now, many people questioned about how your Election Commission of India can do this, and they were angry about Supreme Court also on certain things. What were those? Means Election Commission of India, while you were doing this, you were not transparent. There are no clear rules or laws to deal with this. On your own, you just told this you will do and you just left it. There was a lot of more of violation is what we saw. And you are one of the most strongest organizations. And you avoided scrutiny, that is, you did not even make your data online, or you did not tell the people adequately. With Supreme Court, why are they angry? They are not even the one who conducted this. They felt like you, Supreme Court, saw everything that was happening with SIR. Okay, they allowed for continuation of SIR even though they knew that it was faulty at many points. They also were angry on Supreme Court, telling that you did not rule whether SIR was legal or illegal. You avoided ruling on that. Okay, here and there for few things you told, okay, do this, don't do that, but you did not fix the structural flaw. So, your internal migrants who are in the same state but working in somewhere else, more than 450 million are internal immigrants, and Tamil Nadu is highly vulnerable because lot of them are migrants only. And the strict ordinary residence rule will affect Tamil Nadu more than anyone, and now Tamil Nadu assembly election is coming. Everyone is pointing out their fear on mass disenfranchisement. Okay. So, there is a concept of social audit, wherein let us say in each panchayat, okay, in each municipality, the local members themselves will tell who is the member here, who is not the member here. That is called as social audit. This can be done according to Article 243A and 243J. 243A gives Gram Sabha the powers to see whose name should be in electoral roll or not, and the same is given to the state in 243G. Your Comptroller and Auditor General of India tells that if true form of schemes or anything has to happen, that should happen through social audit, that is through panchayats and municipalities. Okay. So, they are thinking if this social audit happens for SIR, it will be much more better, and this has already once happened also. Okay. This has happened when means during your 2003 period of time, when Chief Election Commissioner J.M. Lindo, he had decentralized the audits in 5 states. For 5 states, he told the local Gram Sabhas and panchayats and states to tell whose name is there in electoral rolls or not. In this, 7 lakh corrections were made after the social audit which was done by the decentralized bodies. So, decentralization helps in your ground level corrections, prevents manipulation, and also it will include large number of voters. Understanding? So, this was a very important thing, and we are telling bring the social audit method to your SIR revisions. Understanding? We will move ahead. So, one question we will see from this topic. Consider the following statements regarding SIR of electoral rolls. It is conducted under RP Act of 1950. Yes. Election Commission can conduct it under this one only. It requires verification of identity, age and ordinary residence. Yes. Social audit of electoral rolls has been recommended to increase transparency. That is why your social audits are there. That is, people should be looking at this voter rolls at local levels. So, all 3 are the correct options. Next is Supreme Court strikes down provision of Tribunal Reforms Act, orders creation of National Tribunal Commission, also very important for your prelims. Done? We will move ahead. First and foremost, this particular act, Tribunal Reforms Act of 2021, which was brought about by government, Supreme Court struck down few aspects of this act. Understand, it did not strike out the entire act. It struck down few parts of this act. Okay? And it also told that create National Tribunal Commission. We have National Commission for SC, National Commission for ST, like that they have told create a National Tribunal Commission to bring in more transparency. Done? Why did they strike down few aspects of Tribunal Reforms Act? Means because they claimed excessive executive control has been there on the tribunals. We'll move ahead. What are the provisions that has been, what tribunals are, what is the constitutional aspect, later I will explain. First we will see the current affair. What are the provisions which have been struck down by your Supreme Court means, they have told if you have to be a member of a tribunal, okay, originally, first I will tell you original provisions. Your Supreme Court had told that minimum qualifications to be a member of tribunal means at least you should have practiced law for 10 years. Okay. So, any young advocate who has practiced for 10 years also, if he is competent, he can become a member of tribunal. Your government in the Tribunal Act, it told that minimum age for a person to be tribunal head will be 50 years. Supreme Court struck this down and told why 50 years, what is your logic behind 50 years? It is very arbitrary, and also this will exclude many competent young professionals. Okay. In other words, tribunal means, let us assume people are having some conflict. Okay. Two types of tribunals are there. One, when your IAS officers, all your civil servants, other is other tribunals, anything apart from your central government post. Now for them and all, one person will come and sit and he will tell, no, whether what you did is right or wrong. That is the tribunal. This is what. Okay. This is almost like judiciary only. But this is almost like judiciary but not judiciary. Judiciary is already overloaded and so many cases are pending. This is to reduce the burden of the dependency on judiciary. So, this person, judiciary I told, if he has practiced law for 10 years, if he is competent, we can make him a tribunal head or a tribunal member. Government told no, he has to be minimum 50 years of age. Understanding? That provision is struck down by Supreme Court. Second is, earlier this person, okay, could be a tribunal member for 5 years. Now government had told no, we will just keep it for 4 years. Okay. The term was also very short. For this reason, even this provision was struck down by judiciary. And let us say if there are 10 tribunal members had to be filled. Government earlier could for one position suggest one name. Now government told no, we will propose 2 names. That is indirectly who that person should be, government will tell, they are telling. Supreme Court struck that down telling no, you will not decide the name, selection committee will decide the name and that will be only one name. So this was also struck down by your judiciary. We'll move ahead. Earlier it was 5 years, government made it to 4 years, that was struck down by the judiciary. Four-year tenure, okay, that is what they brought it. The top ones are what the government made the changes. Declared, your judiciary struck this 4-year tenure because they declared it is too short and they restored the minimum 5-year tenure. 5-year tenure was there from the beginning. Understanding? Next, your judiciary, I told you if a person is coming to you with issue, then you should be a judicial capacity member. Your government had equated all the members to civil servants. Judiciary got enraged over this. The whole point of someone trying to deal with this issue is he has to have judicial capacity. Why should he have civil servant capacity? He is not an executive. So you are violating separation of power, which is a basic structure, which is nothing but our basic structure doctrine, which gets violated if you violate this. So this provision will be struck down because you cannot expect a judicial member to have an executive function. A judicial member should not be treated, or he should not be considered, only a civil servant should be given this position. Understanding? And see, whatever provisions you are seeing in this act, already the same provisions your government had passed through an ordinance. That also judiciary had struck down. Now here judiciary told that you cannot keep overriding the court judgments by keeping on passing different things. First you passed ordinance, we struck that down. Now we are bringing an act, this also we will strike down. Do not bring any more things to keep repeating the things that we are striking down. Done? Now, what are these tribunals? Quasi-judicial bodies which are to reduce the burden of the courts. According to our constitution, 42nd constitutional amendment of 1976 added part 14A, which was article 323A and article 323B. This is where your tribunals concept was added into the constitution. Under 323A we call it as administrative tribunals. (323B) is other tribunals, that is any topic in 7th schedule, that is union list, state list, concurrent list, apart from administrative can be all set up using 323B. Tribunal basically means if any fight is there, you have someone to resolve it, no? That is this. They are to reduce the load of your courts. We'll move ahead. 323A, administrative matters, it will deal only with the civil servants ka issues. Center, state, local bodies, PSU employees, these things. 323B, anything which regarding apart from this is 323B. That could include taxation, land reforms, industrial reforms, any of those. Okay. One question we'll see from this topic. Consider the following statements regarding tribunals in India. Article 323A and 323B were added by 42nd Constitutional Amendment. Correct. Supreme Court directed the creation of National Tribunal Commission. Correct. Tribunal members are considered civil servants under Tribunal Reforms Act. No. No, they are considered as civil servants, means this is the changes they brought about, but it is immediately struck down. So, correct answer is 1 and 2 only. Last topic, revisiting gender neutrality in POCSO Act of 2012. Done? See, first and foremost, why is it in news? Supreme Court has issued a notice that in case of female accused under section 3 of POCSO, this has again reignited the debate of gender neutrality in POCSO case. Write this, then I will explain. Okay. Government has told POCSO basically means prevention of sexual offences on children. Okay. Now here, who are they calling children? Means anyone who is below 18 years of age. Okay. Any form of sexual offences you create on a child will be all coming under POCSO. Now, who is making the child commit, that is either on the child or using the child for doing any of those things? This is an adult. Okay. Now, this adult if they do anything to the child, sexual offences, then they have to be charged under POCSO Act. Okay. POCSO Act means it is more strict, it has to be reduced, that is you have to deal with the case within 1 year. It is to reduce the burden and drag the child further and further. Okay. Now this adult usually, okay, in the act it did not say male anywhere, but this adult could mean male plus female. Okay. Recently a case had come up where an older female had made a child do sexual offences, which led to the child developing a lot of anxiety, depression, all those things. Okay. Now here adult indicates both male and female, it is gender neutral is what your government is also telling, which means if a male does this to a child or a female does this to a child, irrespective of what it is, both have to be tried under POCSO Act only. Understanding? Now if in case a child and a child are involved in this, means they will be tried according to Juvenile Justice Act. Adult and a child means it will be tried under POCSO Act. Understanding? So what is POCSO Act? Protect children from sexual abuse, sexual exploitation and also pornography. Ministry of Women and Child Development had come up with POCSO Act. They also amended this in 2019 where they increased the punishment for people engaging in sexual offences of the children. They also added death penalty for aggravated assaults. Understanding? That is, if the child is less than 16 years of age and someone tries to conduct a lot of offences on the children, the punishment is stricter and stricter. They even added death penalty also to the list. So what are the features of your POCSO Act? Any child who is below 18 years of age will be covered under this act. It is a gender neutral law. It does not mean only a male has to commit, it also includes female. Okay. And types of offences could be including your harassment, sexual in nature or even pornographic content, all of those are brought into this. Aggravated offences, especially if someone is trying to do an offence for a mentally ill child or a trafficked child, all this will also come under stricter punishments of POCSO Act. What are the punishments? See, it starts from minimum 10 years of rigorous imprisonment to life imprisonment. In case you have increased, again based on how the crime is committed, they can even go for 20 years to life to death penalty. And this was added in your amendment where if you had any child pornographic content, even though you did not make it but you have it, means you can be fined or imprisoned up to 7 years. Okay. Based on the crime, the punishments become more stricter. Now, what are the mandatory things under POCSO Act? Special courts must be set up. Evidence recording of the child. Whenever the child has reported, that has to happen within 30 days so as to not put the child through your mental harm. And the trial has to be completed within 1 year when and where possible. And if any other law will tell otherwise, then the only law that will prevail over all the other laws with regarding to child is your POCSO Act, not your Juvenile Justice Act or not your any other act. It is this final act. POCSO Act has overriding effect on all the other acts. Now, the question is this act truly gender neutral? Section 3, yes, definitely uses gender neutral terms. They have nowhere used male only kind of language, but section 13 of 1 tells masculinity words, he or somewhere if it is used means, the government has clarified, see masculine also includes feminine words. He matlab it's not just a male, he or she. or any adult. Okay, that is what they are trying to clarify, because people try to escape with just these kind of legalities. Okay, so the liability is also included as to if in any form you engage the child in trying to do things that is harmful for the child, and in here when we tell harmful for the child, you cannot engage the child in any activities that is considered a sexual offence. So, here Ministry of that is Women and Child Development clarified in Lok Sabha telling that POCSO is gender neutral law. It means it applies to both male and female. And they also confirm in statements of objects and reasons, they told it is completely gender neutral. Done? We will see prelims question on this. Consider the following statements regarding POCSO Act. It defines a child as a person below 18 years of age. It applies only when the offender is an adult male. This is the one thing they are trying to beat out. It has to be an adult, not just a male or female. The act has an overriding effect over other inconsistent laws. In case any other inconsistent laws, means let us say your Hindu Marriage Act. If a marriage has happened between a man and a woman, let us assume the man is 35 years and the child is only 12 years. And if he does something, technically he can tell Hindu Marriage Act pe husband and wife can be close, but it is a child 12 years. So, here we will not consider any Hindu Marriage Act, we will only take in POCSO Act. So, the correct answer is 1 and 3 only. Okay. Clear up until here? Any doubts? Online class, any doubts? This completes current affairs of polity.